Losing a loved one is one of life's most challenging experiences. As families grieve, they are often faced with an overwhelming legal and financial aftermath, known as probate. Please remember, the information in this video is for educational purposes and is not a substitute for professional legal advice. The probate process can be confusing, especially when terms like executor and administrator are thrown around. Our goal today is to clarify these distinct but often confused roles. By the end of this video, you will have the confidence and clarity you need to understand who does what during probate. Let us start with the basics. What exactly is probate? In simple terms, probate is the formal legal process of settling a deceased person's estate. Think of it as the legal bridge between someone passing away and their assets safely reaching their loved ones. But why is this process so critical? First, probate officially validates the deceased person's will. It also allows the court to oversee the identification and protection of all assets, preventing any unauthorized access. Before any property can be distributed, the estate's financial obligations must be cleared. Probate provides a structured timeline and legal framework for notifying creditors, paying off outstanding debts, and settling any final income or estate taxes. Finally, probate legally transfers the remaining property to the rightful heirs or beneficiaries. Whether it is following the exact wishes outlined in a carefully drafted will, or adhering to state intestacy laws if no will exists, probate ensures a fair and legally binding resolution. When someone writes a will, they choose a trusted individual to carry out their final wishes. This person is the executor. Being named an executor is a serious responsibility. Unlike an administrator appointed by the court when there's no will, an executor's authority comes directly from the deceased's written instructions. They act as the estate's chosen guardian. The executor's role begins by filing the original will and death certificate with the probate court. But their work extends far beyond paperwork. They have a strict legal duty to notify all interested parties. This means actively informing named beneficiaries, potential heirs, and any known creditors that the probate process is underway. Once officially appointed, the executor steps into a managerial role. They must locate, inventory, and carefully safeguard all the deceased's assets. This complex task involves managing real estate properties, closing bank accounts, and handling investments. They must also manage the estate's liabilities by paying outstanding debts and filing final taxes, all while maintaining meticulous financial records of every single transaction. After settling the estate's debts, the executor distributes the remaining assets to the beneficiaries exactly as the will dictates. Throughout this process, clear communication is essential. Above all, an executor is bound by a strict fiduciary duty. They are legally obligated to act in utmost good faith, always prioritizing the best interests of the estate and its beneficiaries above their own. What happens if someone passes away without leaving a will, or if the person they named as executor is no longer able or willing to step up? This is where the probate court steps in and appoints an administrator. When a person dies without a will, they are said to have died intestate. In these situations, the court takes the wheel to ensure the estate is properly managed and closed. The role of an administrator is very similar to that of an executor, but with a few extra hurdles. First, a family member or interested party must formally petition the probate court to be appointed. Once approved, the administrator's core duties begin. They must locate and protect the deceased person's assets, pay off any valid debts and taxes, and most importantly, identify the legal heirs. Because there is no will to provide instructions, the administrator must follow strict legal guidelines. Without a will to dictate who gets what, the administrator must distribute the remaining assets strictly according to state intestacy laws. These laws vary by state, but they generally follow a standard order of inheritance. Typically, the surviving spouse is first in line, followed closely by children. If there is no spouse or children, the estate then passes to the deceased person's parents, and if they have passed, it moves down the line to siblings, and then more distant relatives. The administrator ensures this rigid legal hierarchy is followed to the letter. While both roles guide an estate through probate, their origins differ.
An executor is handpicked by the deceased in their will, following those specific instructions with a degree of flexibility. An administrator is appointed by the court when there is no will. Their authority is strictly bound by state laws, leaving little room for personal discretion.
Despite these differences, both share a strict fiduciary duty to act in the highest interest of the estate. Both roles must meticulously locate and manage assets, settle outstanding debts, and navigate the formal legal process. Ultimately, whether chosen by a will or a judge, both must fully report to the court to ensure the estate is fairly resolved.
Handling an estate is a huge responsibility. To protect beneficiaries from mismanagement or fraud, courts often require a probate bond, also known as a fiduciary bond. It acts as an insurance policy, safeguarding the estate's assets while they are managed. Are these bonds always required? Often, a well-drafted will specifically waives the bond, but if there is no will, or if the court demands it, an administrator must post one. The bond's premium is a small percentage of the estate's total value, usually paid directly from the estate funds. For all this hard work, executors and administrators are entitled to compensation. This fee might be specified in the will, set by state law as a percentage of the estate, or based on reasonable compensation for the hours worked. Keep in mind, whether you are an executor or administrator, these fees are considered taxable income and must be reported to the IRS. Navigating probate can feel overwhelming, which is why seeking professional guidance from a qualified probate attorney is highly recommended. An experienced attorney helps you navigate complex legal paperwork, ensures strict compliance with the law, and provides crucial mediation if family disputes arise. Let us address a few frequently asked questions. Can a family member serve as an executor or administrator? Absolutely, provided they meet state legal requirements. But what if duties aren't fulfilled? If an executor mismanages the estate, the court can remove them, and they may be held personally liable. Can estate property be sold? Yes, property can be sold to pay off debts or distribute assets, though court approval is often required. And how long does probate take? Typically, the process lasts from 6 months to over a year, depending on the estate's overall complexity. Finally, what are small estate procedures? Modest estates might qualify for this faster, simplified alternative to formal probate. However, always remember that probate laws vary significantly by state. Consulting local guidelines or your attorney is the best way to navigate probate with confidence. Please remember that this video is strictly for informational purposes and is not legal advice. We strongly encourage you to consult a qualified probate attorney for your specific situation. You can also visit probateus.com/directory to find local probate court information and specific jurisdictional guidelines. Thanks for watching. Thank you for watching. Understanding the differences between an executor and an administrator is your first step towards a smoother probate journey. If you found this helpful, please like and subscribe. Have questions or a story to share? Leave a comment below so we can support each other.